All rise. The Honorables, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save this state and this honorable court. Be seated.
Good morning and welcome to the Court of Appeals. Thank y'all for, I'm glad we were able to work out our scheduling with our big winter events that we have had the last few weeks. And our weather is much better today, so that's good. Panel for your argument this morning, I'm Judge Donna Stroud. To the right we have Judge Michael Stadding. To the left Judge Chris Freeman. And looks like y'all are all ready to go. Have you already got your time reserved for rebuttal of, what time did you reserve for rebuttal, just so I know?
I reserved 5 minutes.
Okay, very good, that's fine, just needed to know. All right, well, we're ready to proceed.
Good morning, Your Honors, and may it please the court. I am James Coleman. I'm representing the appellant, Junior Chandler. And with me at counselor's table is Jamie Lau. Mr. Lau and I are the supervisors of the Duke Wrongful Convictions Clinic. This case requires the court to determine whether the cumulative effect of a long list of favorable evidence withheld by the state from Mr. Chandler and the false and misleading evidence used to convict him, including evidence that the court below found had been fabricated, undermines our confidence that Mr. Chandler received a fair trial within the meaning of Brady versus Maryland and Napu versus Illinois. That is the principal issue before the court, whether there is a reasonable likelihood that those findings could have affected the judgment of the jury. Last year in Glossop versus Oklahoma, the Supreme Court wrote that, quote, in effect, this materiality standard requires the beneficiary of the constitutional error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict obtained. That reflects that the error under Napu is a constitutional one occurring at trial, and that the state shoulders a heavy burden to avoid the consequences of its misconduct and also of the taint on the truth-finding process of the trial. In its brief, the state did not attempt to make such a showing. Rather, it argued, like the court below, that there would have been sufficient evidence to convict Mr. Chandler, even if the tainted evidence and the false evidence had been removed from the case. That is not the appropriate test. As the Supreme Court made clear in Cowles versus Whitley, the defendant does not bear a responsibility to show that he would have been acquitted if the violations had not occurred. He has to show only that in the case of false and misleading evidence, that the state knowingly elicited the false evidence or knowingly allowed the evidence to go uncorrected, and that the false evidence, quote, may have had an effect on the outcome of the trial. The evidence that was withheld and the false evidence and misleading evidence went to the heart of the state's case. It had to do with the credibility of the state's key witnesses and destabilized the bedrock of the state's case against Mr. Chandler. One of the most egregious violations of Mr. Chandler's constitutional rights occurred when the state's 3 key witnesses testified from so-called summaries of their interviews of the children in this case and the state suppressed the transcripts of the actual interviews. The result was that their testimony created a false impression that the children had made reliable accusations that Mr. Chandler had sexually assaulted them. However, the suppressed transcript showed that, like the children's testimony at trial, the statements attributed to the children were the product of interrogations during which 2 to 4 adults bombarded each child with questions and suggestions designed to implicate Mr. Chandler in the alleged misconduct. The court below made findings that made clear the dimension of the misleading nature of the summaries on which the state's key witnesses relied. The court found that the social worker who led the Department of Social Services investigation consolidated and summarized interviews that she and the state's other 2 key witnesses, Dr. Gravatt and Dr. Rice, the medical doctors who examined the children, conducted with the children in this case. All 3 witnesses testified from those summaries when recounting the children's alleged responses to the jury. The summaries omitted instances where the children denied that any abuse occurred and omitted the prevalence and insistency of the adult question, leaving the misleading impression that the path from the inquiries to accusatory responses was a simple exchange. In a case of child sexual abuse, a key issue is the reliability of the accusation. That's why it's important that the interrogation or the interview of the children not put words in their mouth. It's critically important that the people conducting the interview not lead the children, and that the whatever statements the children make are made in their own words and not in the words of the people who are interrogating them. In this case, though, the summaries misleadingly portrayed the children as delivering, as the court said, surefire responses by omitting the fact that the interviewers prompted the oft-confused children with repeated and leading questions. The social worker misleadingly consolidated the interviews into simple accusatory summaries for all 5 of the children who were interviewed and who testified at trial. She not only misleadingly consolidated the interviews, but inserted outright fabrications of details from the original interviews. Many facts the witnesses say the children provided in their interviews appear only in the summaries and not in the verbatim transcripts. All 3 witnesses made some children's responses seem spontaneous when in fact they were the result of the interrogation. The court below considered only whether the testimony of these witnesses was perjury. Because it found that some of the inculpatory words attributed to the children actually appeared in the suppressed transcripts, the court concluded that the testimony was not false within the meaning of NAPU. That is an erroneous understanding of the case. In Hamrick versus Bailey, decided in 1967 by the 4th Circuit, the court held that, quote, evidence may be false either because it is perjured or, though not itself factually inaccurate, because it creates a false impression of facts which are known not to be true. That was also the conclusion of the Supreme Court reached in Miller versus Pate, also in 1967, and most recently, that was the conclusion of the 4th Circuit in Jupiter versus Davis, which was decided in 2023. The state was very familiar with the process of interviewing children and how it should be conducted. The prosecutor reminded the principal doctor that the words that come out of the interview have to be the words of the children. The children should not be led. They should not be badgered. They should not be pressured. And if they did not willingly provide responses to the questions, they should be let alone. The Dr. Bravad, in her testimony in depositions for the evidentiary hearing below, acknowledged that that, in fact, was the standard. She also denied that she had, or they had bombarded witnesses, the children, with questions, or that they had pressured them in any way to implicate Mr. Chandler. In her closing argument to the jury, the prosecutor in this case denied that the doctors had asked leading questions. Mr. Penland, the lawyer who represented Mr. Chandler, lamented to the jury that the interviews had not been recorded so that they could see what had actually happened, because he speculated that the testimony of the three witnesses could not reflect the full case of what had happened. He said if there had been a recording, he was confident that it would have shown that the witnesses had asked leading questions and that otherwise engaged in inappropriate conduct. The prosecutor responded to that argument, not by defending the manner in which the interviews were conducted, but by denying that the witnesses had asked the children leading questions. That was false. And as the transcript clearly shows, the witnesses, over the course of the minutes that they spent with the children, questioned them about whether Mr. Chandler had sexually abused them. They dominated the interviews. I wouldn't have enough time to go through all of the evidence and all of the illustrations of why what we represent happened is true. But what I would like to do is to refer the court to the ordered briefing that we filed in this case, which is found beginning on page 8171 of the record on appeal. And specifically to refer the court to Exhibit 5 of that document, which is a detailed analysis of the differences between the transcripts and the summaries from which the witnesses testified. And one illustration of how much the witnesses dominated the interviews is a chart that's on the first page of Exhibit 5. And what it does is it does a word count. It looks at the entire interview and it counts the number of words spoken by the adults and the number of words spoken by the children. And what it shows is frankly extraordinary. So for example, one child, Michelle, the total number of words were 1,156. The total number of words spoken by the adults were 1,123. The total words spoken by the child were 33. All right? In other words, 2.9% of all the words were spoken by the child. And that included when she said or those were counted as words. And although for the other children it's not as bad as that, The range, though, of percentage of responses from the children went from 7.3% to a high of 11%. So most of the words spoken in the interviews were spoken by the adults. And in some cases, the adults who were in the room included two doctors, a social worker, and often a parent for the child. And they were all, even when the child denied that Mr. Chandler had done anything, they continued to press. One of the things that they would do often is when the child did not mention Mr. Chandler, they would ask who was the bus driver. And the child would, if the child knew, because in some cases the child didn't know, but if the child knew, the child would say, Junior was the bus driver. And then they would ask, well, did Junior do anything that made you, that hurt you, or did he do anything that scared you? In other words, often they would introduce Mr. Chandler's name into the interrogation. The child did not voluntarily raise or make allegations against Mr. Chandler. One other aspect of this case that is unusual is that it started when the parents filed a complaint, a criminal complaint against Mr. Chandler. They heard about the possibility that a threat had been made to the children. They assumed that the threat was in connection with what they thought might have been misconduct by adults on the bus. So they filed a criminal complaint, including parents who accused Mr. Chandler of sexual abuse of their children when there had been no allegation at all made by any of the children that Mr. Chandler had done anything wrong. And in fact, often, in the case of Brandy, who was the oldest of the five children, who was, I think, around 5, she denied in interviews, she denied to her grandmother, she denied to her mother, she volunteered to them that Junior Chandler had not done anything to her. And yet, over a period of time, after many interviews and being subjected to this kind of pressure by the adults, she started to implicate him in what she said and what other children claimed was misconduct that was occurring on the bus. Most of the misconduct related to two intellectually disabled adults who rode on the bus with the children. The children were in daycare. These two intellectually disabled adults were taken back and forth to a program. They sat in the back of the bus. Now, when we talk about the bus or the van, there's a notion that maybe it was a van or a bus with an aisle down the middle, and people could move around. That's not what it was. It was a van with a bench seat, 4 bench seats across from side to side, so that in order to move from one row to another, you had to go outside or climb over the seats. There's no easy access. So for the people in the back of the bus, they were often engaged in what one child called adult or married people's behavior. They were engaged in misconduct, not that affected the children, but with each other. And one of them threatened their children to stop looking back there at what they were doing. That threat became, in the retelling of some of these parents and then the children, it became a threat that they would put the children on the railroad track if they told about sexual misconduct that was happening on the bus. That's not what it was about at all. It was about the children turning around, looking at what the adults were doing. But even with respect to that, Brandy, again, the oldest of the children, told her mother that Junior Chandler had not made any threat against the children. Instead, she said, he told them that he would not let the, the adult do anything to them, that do anything to his children, I think he referred to them. So they go from a threat that there is sexual misconduct involving the children to they turn a threat made by one of the adults against the children because they were looking back at what they were doing. They turned that into a threat relating to sexual misconduct, first by Buddy, the intellectually disabled male, and then by Buddy and Junior. The court found that there were many items of favorable evidence that the state withheld. Some of it related to evidence that two of the children had been sexually abused by adults who lived with them. In one case, it was that the boyfriend of the mother had abused one child. And in another case, it was the father of the girl had abused her, as well as her sister and brother, and that the mother's teenage brothers had also abused them. One of the issues in the case is that the doctors relied on what they said was medical evidence of sexual abuse. They found that the vaginas of the little girls that were dilated, and they said that was evidence that they had been sexually abused. The problem, even if that evidence was valid and the court found that it was antiquated and today would not be viewed as evidence of sexual abuse, but even if it were evidence of sexual abuse, in the case of two of the girls, the question would be who was responsible? Because during the same period that Mr. Chandler is alleged to have sexually abused them, other people also had been accused of abusing them. Now, I mentioned that the parents started this case by filing criminal complaints. After Mr. Chandler and the other two adults had been indicted, the State Bureau of Investigation came into the case to assist with the investigation. But as I said, it had already started, they had been charged, and so the special agent had to catch up. What happened as he started to look into the case is that he concluded that there was only one viable case against Mr. Chandler, and that involved the girl who had, on multiple occasions, denied that Mr. Chandler had ever touched her. But as to the others, he concluded, based on what he was able to investigate after the fact, he concluded that two of the girls were being abused, but not by Mr. Chandler. He thought they were being abused either by the boyfriend of the mother or by their father. When this issue came up at trial, the mother of one of the girls testified. And she was asked whether she was aware that her husband had allegedly abused her children in 1985 before the allegations arose that Mr. Chandler had abused them in 1986. And she testified that she was not aware of that, and that the first time she was aware of any allegation that her husband had abused her three children was in July of '86, after Mr. Chandler had been charged. And she said before that, she was not aware of any evidence that her husband had abused them. That was false. And the evidence that it was false was contained in the files of the state. The SBI special agent interviewed the mother. She told him about an allegation that the father had sexually abused the two girls, including the one who Mr. Chandler allegedly had abused, and that it occurred in 1985, and it likely was continuing. Well, I see I have 5 minutes remaining, so I think I'm going to stop here and reserve my time, and then I will finish it on rebuttal.
All right, thank you.
May it please the court. I am Sherry Lawrence with the North Carolina Department of Justice, along with co-counsel Attorney Kristen McCrary. We represent the state of North Carolina in this case. Attorney McCrary and I will divide our oral argument time in this case. I will address the Brady versus Maryland issue, and Attorney McCrary will address the Nephew versus Illinois issue before this court. This case is before this court on this court's order granting defendant's petition for writ of certiorari to review Judge Gary Gavanis' February 8th, 2024 order on defendant's motion for appropriate relief, addressing solely defendant's Brady and Nephew claims, labeled as Claim 6 and Claim 7 in the trial court's order and the MAR court's order, and defendant's MAR. This court denied review of Judge Gary Gavanis' March 17, 2021 order, determining that the defendant's MAR claims 1 through 5 were procedurally barred under NCGS 15A 1419. Therefore, the sole issues before this court for review are defendant's MAR claim 6, the Brady issue, and defendant's MAR claim 7, the Nephew issue. However, by advancing arguments before this court questioning Linda King, Dr. Gravatt, and Dr. Rice's interrogation and interviewing techniques, defendant is improperly seeking to have this court review his procedurally barred MAR claims as labeled as claims 3 and 4. Such review, as previously stated, is beyond the scope of this court's grant. This court should follow its order granting certiorari, the North Carolina Rules of Appellate Procedure, and this court and our Supreme Court's precedent, and not review the interrogation and interviewing technique issue. To the extent that this court does consider this argument, Dr. Gravatt told us in her deposition the type of protocol that they used. In the record on appeal, specifically at page 3222, Dr. Gravatt, in response to the question by Mr. Coleman, can you describe briefly what the protocol was for interviewing these children? Dr. Gravatt specifically stated, yes, the protocol, unlike interviewing children for sore throats, where the questions are very pointed, the question for children that are allegedly abused or neglected needs to be open-ended questions. Because oftentimes children don't make any statements, there needs to be care to not make statements for the children or put statements in their mind or lead them in any way, or preserving essentially an open palette for the child to make a disclosure. If they choose to make a disclosure and to record what the child stated, as opposed to a child that presents with a medical complaint. So Dr. Gravatt identified in her deposition that was played at the evidentiary hearing for Judge Gavanis exactly the protocol that was used.
So, let me ask, but it doesn't, differentiate for me here how the issues are separated. She says this is the protocol that was used. If the actual evidence shows that that was not the protocol that was used? Are we just to ignore that as far as like, for just example, the word counts?
Well, I guess just as an initial matter, defendant did not, that's part of Judge Gavanus' March 21st order, March 7th, 2021 order. It's not properly been put before this court. However, the testimonies here, it doesn't show that it was unreliable. It clearly shows that they testified, the children disclosed over time, and this is important. Her statements are important at evidentiary hearing because it does show that disclosure where she didn't disclose, BB, for example, and then she continued to disclose more over time. In addition, there was always denials. There was always denial from the kids as to the sexual abuse. However, they implicated Buddy. Most implicated Buddy first. However, then it turned to, they also implicated defendant. As co-counsel pointed out, as the defendant's attorney pointed out, in addition, there were other alternate perpetrators. The state never said that this defendant was the sole perpetrator. So just again, relying on the scope of this court's grant of certiorari, defendant specifically raised that issue as claims 3 and claims 4 in his MAR, and they were procedurally barred. Defendant has not shown any type of actual prejudice and good cause or fundamental miscarriage of justice. He didn't argue that to the trial court to overcome those procedural bars. In addition, I would like to also address the interconnectedness argument the defendant is now lodging in reliance on Juniper versus Davis, the Fourth Circuit case. Defendant's argument was not made before the trial court. Again, it is beyond the scope of this court's grant of certiorari. The defendant did not make any argument before the MAR court regarding the application of this interconnected standard of materiality to the Brady and the Pugh issues as he now raises before this court. So defendant is essentially trying to raise this interconnected argument in reliance on Juniper to get this court to apply the less stringent materiality standard should we get that far. However, this North Carolina follows the regular application of Brady and the regular reasonable probability standard of materiality as to Brady. And any issues as to the Pugh, I would defer to my co-counsel. So in this case, the regular standard of materiality applies, the reasonable probability standard for Brady, and the regular standard under the Pugh also applies. The MAR court determined that the state suppressed favorable evidence, but the MAR court did not determine that the defendant did not meet his burden to show a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. Therefore, materiality is the sole issue as to the Brady claim for determination. The MAR court applied the correct standard. Before beginning the Brady analysis, the MAR court set out and applied that standard. The MAR court stated, evidence is considered material if there is a reasonable probability of a different result had the evidence been disclosed. The MAR court continued saying the defendant must show that the government suppression of evidence would undermine confidence in the outcome of the trial. The MAR court then further stated a reasonable probability is more than a mere possibility. A defendant's burden there on a Brady claim is more than showing that the withheld evidence might have affected the verdict, but less than showing that withheld evidence more likely than not affected the verdict. Viewing the context of the entire record, a defendant argues that the trial court applied a sufficiency of the standard evidence. Cases do set out that it is not a sufficiency of the evidence standard. That is correct, it's not. However, cases also cite that you have to consider the outcome. What effect did the cumulative effect of the undisclosed favorable evidence have on the outcome of the trial? In fact, our Supreme Court in State versus McDowell stated that undisclosed evidence must be viewed in the terms of its effect on the jury. Since the jury determines guilt or innocence based solely on its evaluation, and its evaluation alone of the evidence, reviewing courts must assess the undisclosed evidence as it would likely impact upon the jury. So in making that determination, you have to consider the trial evidence. The questions become, did this undisclosed favorable evidence contradict or weaken the state's case? And I'll go through some pieces of evidence in the time that I have. Another important question is, did it significantly impeach a substantial witnesses? Now, I know defendant will argue that all of the children were very important because they implicated defendant. Correct. However, if we look at the trial summaries or the interview transcripts and compare to the interview summaries, are actually transcripts that were found to be undisclosed and favorable, what do they show us? They still show us exactly what each child testified to at trial, that they were sexually abused by defendant. Were they only sexually abused by defendant? No. MC was sexually abused by Big Ricky, her father. QR was also sexually abused by Jerry. All of that evidence was before the trial court. All of that evidence was before the jury. The interview notes do not disclose any additional evidence that was not already before the jury.
Say they don't review maybe anything additional, but they show something about how they got those answers out of very young children. Is that, you know, that can make a big difference at how evidence is perceived. We all know young children in those circumstances are can be very much influenced by what they're asked.
Correct, and I understand that. However, on the facts of this case, that is not shown through the question or the reveal or the disclosure of these interview summaries, these interview transcripts rather. It shows exactly what Dr. Gravatt talked about in her deposition. It shows a gradual statement. They didn't make her have a statement. I mean, I think if the allegation is that the prosecutor and these experts fabricated these statements, they didn't do a really good job of doing it. They would have done a better job of doing it. Why not do it the first time? Get it the first time. So it goes exactly to the protocol that Dr. Gravatt testified that is used, the proper protocol that should be used. If the child makes one statement, that's fine. However, BB disclosed over time. It took her some while to disclose. And there's, in all cases, I think the court can take judicial notice, a lot of child sex cases, the child doesn't immediately say, so-and-so abused me, especially when you have 2 or 3 perpetrators. In this particular
And how old were
case,
these children? You said how old was that child?
BB was a minor. All the children were 5 and under.
Right.
BB specifically, she was 4 or 5 years old during this time. So she was born in February of 1986. This occurred in 1986. So she would have he just turned 5, according to my math, if it's correct. So all of the children were under the age of 5 or thereunder. BN was 5 at the time as well. MC was 4. QR was 5. AR was 3. JS was 3. And TN also was 3 years old. So in addition to these experts, we also have Phyllis Wells. We also have Becky Lasher. These 2 people are important because they provided therapy to these kids after the fact. So the therapy sessions revealed what? These kids had behavioral changes. Who noted the changes? The parents. For instance, BB, her changes, withdrawals, nightmares, fear of strangers, especially males, clinginess, whining, disobedience. She also displayed quite a bit of masturbatory activity with toys in her hands. BN, he also had behavioral changes. He became very aggressive, open mouth kissing that he engaged in with his therapist, or tried to rather. He wanted to rub his body against Mrs. Wells' body. He got agitated at the mention of his body. He became nervous, clingy, angry, distrustful. He said Junior touched his private part with his hand. He kissed his boo-boos. He pointed to his breast area. MC also had behavioral changes. Her mom described her as being normally active, very talkative, and played with her siblings. However, she began to cry a lot. cried when she got on the daycare van, became nervous. She would sit for hours with her head hung and not talk. And this is coming from her mother. She started wetting the bed again. In addition, with Becky Lasher, MC drew a picture of a scary man named Junior. She identified on the picture Junior's ding dong with pee coming out of it.
Now, were these after the questioning by the interviewers?
Yes,
Yeah,
they
this
were
therapy was after they
That's
had
correct.
done all that, so,
That's correct.
right.
And even assuming these are independent therapists. So we have a 3, 4, 5-year-old that's taking a picture utilizing anatomical dolls that are undressed, pointing to the male doll's penis and saying, "There's his ding dong."
The interviewers had already done that with them before that, right?
They had utilized some anatomical dolls, correct. However, Becky Lasher, during that interview with her, MC said, "Big Ricky and Junior messed with my butt." In addition, behavioral changes. So again, you can't force behavioral changes. And that's why I think this is very important as well.
Well, you can have a case where if a child is convinced after having been questioned for hours and hours and hours and hours about something happening, and a 3-year-old, it's happened to them, whether it happened or not. I don't remember my 3rd birthday, but I've been told about it many times. I think I remember it.
I think what's important here, though, is the fact that we have a mother. We have mothers displaying and seeing these things. For instance, one of the mothers being BB's mother stated she told her mama, "We've been effing." She got off the van. That's what started this report. So that was before Linda King, before Dr. Gravatt and Dr. Rice got involved. She came home and told her mama, "We've been effing on the book. We've been effing." That's what started this. That's what started this investigation. She stated they hurt her butt on the daycare van, threatened to put her on the railroad tracks. She simulated sexual acts with the teddy bear. So these are things, again, that the mother saw. So there's lots of independent evidence outside that occurred beforehand, outside of these interviews that implicates defendant. Pam and Buddy, both of them corroborated those statements. And defendant claims that those denials were not provided to him. However, during the trial, Buddy testified. Pam testified. Mr. Peelan cross-examined them about their mental retardation. It was stated in their agreement for truthful testimony that they were easily suggestible. So all these things were brought out. All these things were there. Buddy implicated himself. Buddy stated, "Yes, I participated." Did he initially deny? Yes, he did. But he told his own attorney, "Yes, I participated in these acts." And I see that I'm going over my co-counsel's time, but I asked the court to consider that independent evidence. I asked this court also to consider their certiorari grant to review the February 8th order. And would ask this court not to review the March order that's not properly before this court. And if there are no further questions, we'd ask you to affirm the trial court's order as to the Brady issue, and I will defer to my co-counsel as to the review.
Right, thank you.
May it please the court. In considering the alleged NAPU violation, the MAR court concluded an important point to highlight. That Dr. Gravatt, Dr. Rice, and Linda King testified to statements the children actually made in their interviews implicating defendant. That's in the record on page 8276, line 26. The MAR court properly concluded defendant failed to prove the existence of a NAPU violation, concluding in the state's favor as to each prong because the testimonies were not false, 1, 2, not material, and 3, not knowingly and intelligently presented as false testimonies by the prosecution. In Glossop, to establish a NAPU violation, a defendant must show that the prosecution knowingly solicited false testimony or knowingly allowed it to go uncorrected when it appeared. If the defendant makes that showing, a new trial is warranted so long as the false testimony may have had an effect on the outcome of the trial. That is, if it is in any reasonable likelihood could have affected the judgment of the jury. At the outset, I want to emphasize the point my co-counsel stated about claims 3 and 4 regarding the suggestible interviewing techniques issue that is not before this court. And I want to also emphasize the fact that the MAR court found that these testimonies were not false. Looking at what we have before us, the MAR court concluded that the testimonies of Dr. Gravatt, Dr. Rice, and social worker King that reference notes and condensed summaries prepared by Linda King were not false as compared to the longer transcripts from the tape-recorded interviews. Why? Because the children identified defendant as the perpetrator of sexual abuse when they talked to these witnesses. Their testimonies were not so substantively different from the transcripts. The conclusion factored in factual findings that defendant's counsel articulated from the MAR court order about the misleading consolidation into oversimplified summaries that omitted denials and added fabricated details. The MAR court, however, rejected defendant's argument that the testimonies themselves were misleading, explaining had the witnesses testified that the victims implicated defendant when they never did, that would be a clear satisfaction of the falsehood requirement. Instead, truncating or summarizing certain details is not falsity under NAPU. The children still pointed to defendant as a perpetrator. The doctors also documented that the children implicated defendant as a perpetrator of sexual abuse in the children's medical records. The MAR court determined as an unchallenged finding of fact that defendant's trial counsel received medical evaluation reports and discovery. That's in the record on page 8271, finding 11E. This is also in the record on pages 3703 to 04, where the state provided the medical records to defendant prior to trial. That's documented there with that supplemental discovery. Defendant's trial counsel also approached several times during cross-examination to view notes these witnesses had referred to during testimony. Those medical records are important because they're an independent source of notes in which medical professionals documented their treatment and diagnosis that the witnesses referenced while testifying. And they were talking about the children having identified the defendant as the perpetrator. We see Dr. Gravatt talk about how some of this kind of helps us put some context to these tape recording interviews, because she talks about how the tape conversations, a lot of the taping did not totally come across, which is why there are some blanks. You can see that when you look at the actual transcripts. That's in the record from her testimony on page 1385. Additionally, Dr. Rice responded during cross-examination concerning BB's statements based on notes she wrote from her medical examination on May 29, 1986 in BB's medical chart. Dr. Rice summarized in her own words what she heard BB say is what she wrote. "It is not what Linda King told me," she said. "I don't remember at which time I came in the room, whether I was in the room at the beginning of the tape, at which time she did say Junior stuck a pin in my butt. But when I wrote this, it is what I heard her tell. It is not what Linda King told me," she said. That's in BB's medical records, and that's something to note also. In the record on page 4762, Dr. Rice has a handwritten note, "Junior put a pin up her butt," pointing to her vagina. Of interest with BB, just as a side note there, when we look at BB, we have Dr. Rice testifying on May 19th when she saw her. BB denied that anyone had touched her. Days later, when she talks to her again and talks to Dr. Gravatt on May 29th, that is when she says the defendant hurt her by sticking a pin in her butt. And so that initial denial, Dr. Rice had that before the jury. When we look at kind of the context of that with BB, we look at the fact that, sure, there is consolidation at work and there is less surefire response with question and answer, like the Mayor Court found. But if we compare what she actually was saying, she is the person who's bringing in Junior's name. And I think that's a note for the court. Who entered defendant's name? When we talk about the MAR court looking at mere inconsistent testimony, it's not enough to say that it's false testimony under NAPU. There's a difference between knowing prosecution of false testimony and knowing the testimony conflicts in some manner. Turning to MC for a moment, that was mentioned about the total number of words that were being asked for all the questions. She was terrified. And so some context, a 3-year-old is in there terrified, not wanting to speak. And Dr. Gravatt testified to that. Dr. Gravatt testified to that on page 1394 that she was virtually impossible to talk to. But in that buildup, if you look back at the transcript, her words are the same as the summary, are the same as what Dr. Gravatt said, that Junior hurt me. So they gave her a break, and that's when she said it was after the break. But there is a barrage of questions trying to get her to talk, like, you can talk to us. And they gave her a break, had her come back with her mom, and that's when MC said, Junior hurt me. That is her words. That's in there from the transcript to what Dr. Gravatt said. And that's the case with the other kids as well. So these mere inconsistencies, that's what the court looked at. Turning to materiality, the MAR court properly concluded that in addition to the testimonies not being false, the NAPU claims also failed as to materiality. Even without articulating the full context of these interviews, inconsistencies, and the process in which the children disclosed that my co-counsel was talking about over time, where we have BB denying it in front of the jury with Dr. Rice's testimony on May 19th, and then saying that the defendant hurt her, that disclosure over time, even with that, all of that was before the jury, and that was something the jury had in front of them. The clear message of defendant's abuse was also before the jury. So we look at how the jury additionally heard testimony from these children, and they had a chance to assess their credibility. BB, BN, QR, and AR testified during the second trial, and MC's testimony was read into the jury as substantive evidence from the first trial because of her fear-based unavailability. Each child told that the defendants touched him or her and inserted either a pin, a stick, a finger, or his penis into his or her genital area or bottom. As the MAR court considered, this court should also look at, with regard to materiality, looking at additional substantiating information, like the unchallenged expert testimony that my co-counsel covered about the therapist Wells and Lasher. The physical evidence, however antiquated, the MAR court found, was before the jury to weigh along with the other evidence. 4 of the 5 children in question here, the 4 girls, BB, QR, AR, and MC, all had dilated vaginal openings and no visible hymeneal rings. BB's vaginal opening was described as gaping, a tremendous finding to the doctors that they noticed. And that's something that was still before the jury. Further, additional testimonies were given that substantiated the allegations. Statements from co-defendants that confirmed the abuse, like my co-counsel discussed. Statements from their parents about the kids' behavior, like my co-counsel discussed, and late drop-offs. Statements from others who observed the van in the area where it wasn't supposed to be, where this abuse allegedly took place, that Pam and Buddy, the co-defendants, talked about. According to the defendant's supervisor at work, that he had no reason to be there. The MAR court properly concluded that the NAPU claims fail as to materiality because there was not a reasonable likelihood that the suppressed transcripts and testimony utilizing the summaries could have affected the judgment of the jury, given the inculpatory statements the kids actually made that these witnesses testified to and the rest of the substantiating evidence, including the jury's opportunity to assess the credibility of the children for themselves when they testified and they identified the defendant as the perpetrator of the sexual abuse. Kind of going back to BB for just a moment. Also, BB, there is a typed statement, but it's not prepared by Linda King. So I would ask the court to look at that kind of with a note within that as well. On page 4934 of the record, that does not contain the same indication that it was prepared by Linda King. And again, I would refer the court back to just the context-related situation there. Specifically, really, defendant is challenging the rhythm of how that conversation is occurring. That Dr. Gravatt says she recalls when she first began the exam that BB was scared. She was a 5-year-old little girl. And that she said, "Are you going to stick something in my butt?" So that part of it did not come through exactly the same way. But when we look at what the transcript says, the question is still open-ended. Has anybody stuck something in your butt? The answer is Junior. The answer is the defendant. So she's the one bringing the name. And if you look at each one, that's where that is. Finally, the kind of crux of where we are with NAPU. The MAR court properly concluded that the NAPU claims failed because the prosecutors did not knowingly and intentionally use false information. The MAR court rejected defendants' argument concerning the creation of a false impression and concluded instead that the witnesses testified to what the victims actually said. They were not creating a false impression because they largely reflected with accuracy the substantive information that victims shared with the interviewers. Defendant has failed to show a knowing intentional use of false information by the prosecutors. The situation is completely different from that in NAPU or Glossop. It's distinguishable here. In Glossop, the instant facts are distinguishable from Glossop when the state allowed the witness to testify falsely that he had never seen a psychiatrist when a jail psychiatrist had prescribed him lithium for bipolar disorder. It was blatantly false, and the prosecutor knew it, and the AG's office conceded to that. In contrast to this case, the prosecutor knew each child pointed to defendant as a perpetrator of sexual abuse and that the witnesses had that information at their disposal, which included treatment notes and the medical records. Practically speaking, it'd be illogical to think the prosecutors were trying to deceive the jury when the children themselves testified the defendant abused them. That information was before the witnesses, and that information was presented to the jury. In closing, the children identified defendant as a perpetrator of sexual abuse. Their testimonies were not false because the children actually communicated that to the doctors and social worker, that they were hurt, how they were hurt, and defendant hurt them. Defendant ultimately failed to show that the prosecution knowingly used or failed to correct false testimony. We'd ask that the court affirm the mayor court's order that there's no Grady and NAPU violation established. Thank you.
Thank you.
I'll be brief. I think it's important for the court to consider that this was, Mr. Chandler was convicted in a second trial. The first trial ended in a hung jury. That's relevant because it shows the weakness of the state's case. And the Supreme Court in Cowles versus Whitley points to that as a factor that a court should take into consideration in assessing the materiality of the evidence that was suppressed or the false evidence. Even without knowing about the false evidence and without the favorable evidence that was excluded, Mr. Chandler was almost acquitted in the first trial. So in the second trial, he was convicted because the doctors doubled down on the summaries and testified from them. And as the court found, they were misleading in terms of what had happened. I want to point out an example. The summary for Brian Nipper on page 6107 of the record, it has the child saying, "Touched my pee." The social worker asks, "Who touched your pee?" The child says, "Junior, Buddy, Funny, Nokia." The actual transcript of that interview he was asked who touched his pee, and he said, "The Buddy." And they said, "Buddy?" And he says, "Yes, Buddy the Pinocchio." And then they said, "Buddy and who else?" And he says, "Pinocchio, too, no more people." And the social worker says, "So no more people? So only Pinocchio and Buddy touched you. Who else? Did you say somebody else that I didn't hear?" Brian, "No." Nothing in here about Junior touching his pee. On the question of what Brandy said when Dr. Gravatt walked into the examination room, the transcript, the summary says she asked the question of the doctor, are you going to put something in my butt? Counsel corrected that, but did it in a way that made it sound like this was not really a big difference between what the summary said and what actually happened. But what actually happened was, as the doctor is examining her, the doctor asks, has anyone ever stuck anything in your butt? That's a leading question. I mean, it came out of the blue. And you know, that's the nature of these transcripts. What the jury heard did not include any of the evidence that was suppressed. The jury did not know that at least one of the mothers had lied about whether her child had been sexually assaulted by her husband. And it appeared that she did so in order to protect her boyfriend. The other child who was sexually assaulted by another adult, the doctors were not aware of either of those two cases. And so they were not able to take it into consideration. So I'm finished. So I will end on that and ask the court to reverse, vacate the conviction, and then remand. Thank you.
Thank you all very much for your arguments. We will recess.
All rise. This session of the North Carolina Court of Appeals is now adjourned.